Okay? Sige, good evening everyone. So, our topic is bulk sales law. This is our last topic for the midterm. So, yung midterms will consist of obligations of the vendor up until bulk sales law. Okay? Kasama ang assignment of credits pati ang barter. Okay? So, bulk sales law. Okay? Section 1 of the bulk sales law states that this act shall be known as the bulk sales law. Okay? Section 2, under that, it says here that the bulk sales law was enacted to prevent the defrauding of creditors by the secret sale in bulk of substantially all of a merchant's stock of goods. So, the bulk sales law was enacted because there are many instances that merchants, okay, so ang seller sa bulk sales law is hindi yung normal na seller, okay, kundi merchants or those people involved in the daily trade, okay, of goods, stocks, wares, okay? So, hindi normal seller ang involved dito, kundi mga merchants, okay? There are instances kasi before that, since sabi ko na, I already laid the ground, the merchants, of course, businessmen itong mga tao na to, they need capital. Okay, they need capital to finance their business, mainly to buy inventory of goods or to engage sila sa buying and selling ng furnitures. They need capital or money. Okay? In your word, capital or equity. Okay? Alam niyo yan, di ba? Kasi napag-aaralan niyo yan, di ba? Okay? You can get that through equity or you can get that through debt. Capital can be financed through equity or through debt. In this instance, it is financed through debt. Okay? And in most cases, kasi before ang nangyayari, si merchant, nabenta niya na lahat ng stocks niya, lahat ng mga pwede niyang ibenta, pero hindi pa siya nakakabayad kay creditor. Okay, so saan napupunta yung pera? Or, kapag sisigil na si creditor, sa kanya ibibenta lahat ng stocks niya para walang makuha sa creditor. Kaya defrauding of creditors. Kasi, as you have learned probably in your obligations and contracts, okay, the creditor can go after una-muna, of course, your money. Pag wala ka ng pera, they can go after your property. Okay? Kasama dyan yung mga binibenta mo sa business mo. Okay? Can you imagine if a creditor, a merchant, expecting payment, pero walang, and then habang hindi pa due yung utang, binibenta na pala ni seller lahat ng goods niya para wala siyang mahabol kay seller or kay merchant. Okay? That's why the bulk sales law was enacted to prevent that scheme by the merchants. Okay? Sabi dito, the bulk sales law intends to declare such bulk sales as fraudulent and void as to creditors of the credit. So ngayon pa lang, i-discuss ko na, okay? The transaction between the seller in bulk and the buyer in bulk is a valid sale. Okay? It is a valid as between the seller and the buyer. But if that is covered by the bulk sales law, and hindi mo ginawa yung mga dapat gawin under the bulk sales law, okay, ang sale nyo magiging fraudulent and void as to creditors. But it will remain valid between the two of you. Kung kayo lang ang concern, valid yan. Pero kung mayroong creditor, void yan. Gets? So kung kayong dalawa lang nag-uusap, that's right. Pero once na mayroong palang na-defraud na creditor, that is void. As to the creditor. As to you, that is valid. Sir, if sinasabi mong valid, the title passes to the buyer from the seller, yes, the title will pass. Okay. Basta lagi as to the creditor, hindi siya valid. Yes? Ano yung kailangan mong gawin? Merong short summary dito. Unless specified formalities are observed, such as the demanding and the giving of a list of creditors. Discuss natin yan sa isa. The giving of actual or constructive notice to such creditors, and by record or otherwise, the making of an inventory. Tatlo lang yan. Yung sa sinabi ko, may 5 kayong dapat gawin, di ba? Okay? So, yan yung mga dapat mong gawin if you are selling goods in bulk or sales in bulk. Okay? Or bulk sales. Okay? So, ano nga ba? Kailan natin masasabi na mayroong sales in bulk or paano mag-a-apply ang bulk sales law when there is sale in bulk? So what are those? These are the 3 categories that will probably make the bulk sales law applicable. The first is any sale, transfer, mortgage, or assignment. So hindi lang siya sale, pati mortgage. Pag mortgage mo, stock of goods, wares, merchandise, provisions, or materials otherwise than in the ordinary course of trade and the regular prosecution of the business of the vendor, mortgagor, transferor, or assignor, or pag binenta mo all or substantially all of the business or trade conducted by the vendor, mortgagor, transferor, assignor, or all or substantially all of the fixtures and equipments used in and about the business. Okay? Pag binenta mo yung mga yan, dyan lang mag-apply ang bulk sales law. So kapag hindi yan ang binenta, hindi siya mag-apply. Okay? So, essentially, you are selling your business. Okay? This is done to defraud creditors kasi kung wala ka ng business, wala nang hahabulin sa yung creditors. If you are a merchant, if you are a full-time merchant, okay? That is done to defraud them. That's why in-enact ang bulk sales law to prevent that scheme. Gets? Kung fixtures and equipment binibenta mo, ayan. Kung goods, ayan. Or yan. Okay? Ito, fixtures and equipment used in and about the business. Okay? So yung binibenta mo sa business. Gets? Gets? Diyan mag-a-apply ang bulk sales law. The exceptions. Okay? The exceptions. So, sabi ko kanina, di ba, kailangan mong gumawa ng, kailangan mong i-lista yung creditors, magbigay ka ng notice sa creditors, gumawa ng inventory, tama? Kapag yan ang mga binenta mo. But, you don't need to do that if exception. Kasali sila sa exception. Una, there is a written waiver from the creditors. Okay? Hindi ka na kailangan gumawa ng list, hindi ka na kailangan mag-inventory, hindi mo na kailangan notify sa creditor. Basta may written waiver. Gets? Second, kapag yung vendor, mortgagor, transfer, or signer is not acting in his own capacity. Meaning, he is acting as an executor, administrator, receiver, signing, insolvency, or public officer. Meaning, hindi siya nag-act for himself. Kapag executor, there is a last will and testament, he only executes the last will and testament. Kapag administrator, walang last will and testament, he only administers the estate of the deceased person. Okay? Kapag receiver, in case na bankruptcy or insolvency. Or if you are a public officer acting under judicial process, hindi siya sakop ng bulk sales law kahit pa yung binenta niya pasok dun sa definition of sales in bulk. Gets ba? Question? So, sino yung sellers? I explained this already. Mga merchants, retailers, okay? Those persons of that class. Okay? So, hindi yung normal na buyer and seller na pwedeng ikaw at saka ako. And for creditors, all persons who are creditors of the seller at the time of the sale. Okay, so if you are a creditor at the time of the sale, you are considered as a creditor under the bulk sales law. Okay? And although they were not creditors for the merchandise, but kasali pa ang general creditors of the seller. Meaning, hindi ka yung nag-finance ng goods, ng furnitures, pero ikaw yung creditor niya kasi, let's say for example, nag-loan siya sa'yo, or ikaw si Globe, meron siyang plan sa'yo, ikaw si Pag-ibig, meron siyang housing loan or motor vehicle loan sa'yo, general creditors. Ito kasi, creditors, time of the sale, okay? Time of the sale. Okay, but the important thing to know is the time here at the time of the sale kasi ang sabi natin, only those who are creditors at the time of the sale complete off are entitled to the benefits of this statute. Creditors whose claims came into existence subsequent to the sale are not protected thereby. So, ang timeline mo dyan, if this is the time of the sale, if pasok ka dito, you are considered as a creditor under the bulk sales law. But if you're a creditor, okay, subsequent to the sale, so dito ka, kahit pa creditor ka talaga niya, kung dito ka lang nag-exist, dito ka lang pumasok sa eksena, hindi ka considered as creditor. You are considered as a creditor for general purposes sake. Under the civil law, you are a creditor. But for bulk sales law, you are not a creditor. Yes? Here's the first thing you do. Okay, you must execute a written sworn statement. Sino mag-execute nito? Si vendor, si mortgagor, si transferor, okay? Si assigner, siya ang mag-execute ng written sworn statement, okay? Ano ito? Whether the sale is for cash or credit, okay? Itong written sworn statement na to, kailangan mong ibigay sa buyer, deliver to the vendee, before may ma-receive kang purchase price or kung credit yan, promissory note, memorandum or other evidence. So before siya magbigay ng partial payment or kung pautang yan ng promissory note, before mo matanggap yun, dapat may bigay mo ang written sworn statement. Ano yung laman ng written sworn statement? Of course, in Tagalog, sinumpa ang salaysay. Ano ang sinasalaysay mo? Na binibenta mo yung mga gamit na yan at meron kang ito, number 1, creditors. Kasama ang names and address of all creditors. Lahat, Hindi pwedeng may mamiss kang isa. Okay. Names and address of all creditors na pinagkakautangan mo, the amount, and whether it's due or it will become due, okay, to each of the said creditors. So, i-classify mo din siya. Okay? Yan ang nasa written sworn statement mo. Kailangan mo itong ibigay kay buyer before ka may ma-receive na pera. Before ka may ma-receive na promissory note or other forms of document or evidencing a credit transaction. Okay? Gets? Whether cash or credit yan, Sufficiency of statement, there must be a substantial compliance to what I said before. Okay, dapat substantially complied. Sir, paano kung verbal statement? Wala naman akong pinagkakautangan, wala akong creditor. Kailangan ko pa rin bang magsulat ng written sworn statement? Yes. Okay. A mere verbal statement that the seller had no creditors is not sufficient. Okay, it's not sufficient compliance. What you must have to do is, you must submit an unequivocal statement, okay, of this fact to the buyer. Okay? Itong written sworn statement na to is executed under oath and in writing, of course, specially the written sworn statement. Okay? Hindi ka pwedeng sumumpa kay buyer na wala kang pinagkakautangan. Okay? Kasi the tendency is, without this law, do you think that sellers would disclose kung sino pinagkakautangan nila? No, di ba? No. Okay? That's why this law is very important. Okay? Next, an affidavit stating that the stock is sold, the stock sold is entirely free from debt and that there is no encumbrance thereon except a certain chattel mortgage given to a specified person is insufficient as against existing creditors of the seller. Diba? Kailangan mong pangalanan, pati address, kung magkano, kung kailan siya mag-due. Okay? So all the details of your loan or your credit transaction must be stated in the written sworn statement. Otherwise, it will become ineffectual. Okay? So kahit yung hindi lang pagbigay ng address ng creditors is not substantial compliance. So dapat mayroong address. Okay? Gets? Gets. Question? Wala? Wala. Effect of false statement. If the statement is fair upon its face and the buyer has no knowledge of its incorrectness and nothing to put him in inquiry about it, he will be protected in his purchase. Meaning, if the buyer has no knowledge that the statement is not true, okay, he will not be liable therefore. Hindi naman kasi si buyer ang magde-determine kung tama yung nilagay mo doon. Paano kung nag-submit ka nga pero may mga omissions? Of course, the buyer will not know. For him, that is true and correct. Malalaman na lang yan later on pag nagkabayaran na or kapag meron na nag-demand na sa iyo as a seller. Okay? If the seller misrepresents, ito na, the amount of his indebtedness, the creditor has no remedy against the goods sold, but he can prosecute the seller criminally. Of course, kung hindi mo nilagay lahat sa written sworn statement mo, and because of that, naniwala si buyer, you can be liable for estafa. Since that is a written sworn statement, it means na nanunumpa ka na lahat ng sinabi mo sa papel na yan ay totoo. Walang labis, walang kulang. At merong kulang dyan, merong kang hindi nilagay, that is perjury. In the first place, that's perjury. Why? Because that is a statement under oath. And you lied under oath. Okay. Second, falsification. Why? Because being executed under oath, that forms part of a public document. And mas malaki ang punishment for falsification of public document. Okay? Next, the statute declares the sale void only in the failure of the purchaser to do what is required of him. It does not declare the sale void if the list of creditors furnished by a vendor on their own is not in fact full, accurate, and complete. Of course, this is supporting yung sinabi ko kanina na it does not in any way make the purchaser responsible for any incorrectness in this. Okay, hindi si buyer mag-determine whether correct or incorrect yung nasa list. Okay? Sa kanya, kapag binigay mo yung list, of course, operating under the law, sa tingin niya, yun yung tama. Okay? Section 4, failure to comply to Section 3. Okay? And, una, failure to comply, meaning, hindi ka nagbigay ng written sworn statement. You must deliver that, sabi kanina, deliver to the vendee. Okay? Una, you deliver to the vendee and apply the purchase or mortgage money of the said property to the pro rata payment of the bona fide claims of the creditors of the vendor or mortgagor. So under Section 4, dalawang hindi mo ginawa. Okay? We did not deliver the sworn statement and we did not apply the money to the pro rata payment of the claims of the creditor. So, as you can see, kung meron siyang creditor, madami siyang creditor, kanya-kanya sila ng claims. Okay? Dapat, pagka-collect mo ng pera kay buyer, kaagad mo siyang i-apply or kaagad mo bayaran kay creditors. If you didn't do that, that is considered as a violation of the bulk sales law, meaning the sale will be declared as fraudulent and good. Okay? So here, makikita mo yung responsibility na nakalagay kay vendor. Okay? Kay vendor. Why? Kasi yung sale may be done to defraud the creditor. Okay? Kaya niya binenta yan in the first place, baka naman gagaguhin niya si creditor. Ganun yun eh. Nasa obligations and contracts pa lang kayo, meron na yan, di ba? Hindi. Sure ako, na-encounter nyo na yung instances na madedefraud ang creditor. Protected ang rights ng creditor. Okay? Mas lalo lang in-specify ni bulk sales law. Okay? Questions? None? Madali? Naintindihan? Okay. Section 4 also state what is meant by secret conveyance. In Section 4 kanina, you did not deliver the sworn statement, you did not apply the payment to the creditors. That makes it a secret conveyance. Okay, yun yung una. Unaccompanied by a sworn list of creditors and without previous payment of the credits. Yan yung Section 4. Okay? Secret siya kasi hindi mo ni-inform si creditor. Yes? Yes. Okay, and those made gratuitously or for a nominal consideration. They are secret conveyances. Why? Kasi those goods, those furnitures and equipments are sold gratuitously, walang bayad, parang dinonate, parang binigay, or may bayad nga pero sa contract lang, nominal. Okay? That means, na wala kang nakuha ng pera. Inutang mo yun, meron kang creditors. So ano ngayon ang pambabayad mo kung libre mo binigay? Tama ba? Wala. Di ba? Sabihin mo kay creditor, wala, binigay ko lang. Walang bayad. O, paano mo yan babayaran? Diba? Di napakamat si creditor. Diba? Pangilang tao, utang-utang. Diba? Tama. Nominal consideration, ano yung simulated price? Okay. Merong naka-state na price, pero nasa contract lang. Nominal lang. In reality, wala. Okay? Siyempre, yung defraud, kumbaga, sa term natin, nagago si creditor, ginagago mo yung creditor. Diba, gagaguhin mo siya kasi libre. Gagaguhin mo siya kasi wala ka namang nakuhang price talaga. Or, you intend to not do what is stated in Section 4, which is to execute a sworn list of creditors and deliver to the creditors, to the buyer, and apply the payment to their credits. Dapat gawin mo yun as a vendor. Otherwise, that could be considered as secret conveyance. Gets? Okay? Section 4. So, regardless if the buyer is in good faith or is in bad faith, okay, the sale may be considered as null and void. Okay? Kapag hindi mo ginawa yung elements of Section 3 and Section 4. So, regardless of their good faith or bad faith, that can be declared as null and void. Questions? Kapag iba ang ang null sa annul. Gets? Ang null, it's inexistent from the very beginning. Kaya ang sabi dyan, it's never have been, it is considered, or they may treat that as never having been made and proceed to the execution levy on the properties thus sold. Parang walang sale na nangyari. Kahit pa meron. It is declared as null and void. Okay? Pag annul, meron, okay, napawalang visa lang. Meron siya, nullify siya, annul na. Okay? Kapag null, wala talaga siya from the very beginning. Okay? Kasi yung goods na yan, yung goods, yung furnitures, yung equipments na yan, pwede yung i-levy ni creditor. Na-explain ko na kanina, kung wala kayong pera, di ba, they go after your properties. Kasama yung goods niya. Okay? So, kapag binenta mo yan, wala nang habulin sa'yo, wala ka na rin pera. Di ba? Ganun yung senaryo na iniwasan ni bulk sales law. Okay? Rights and liabilities as between the purchaser and creditors. A purchaser in violation of the bulk sales law acquires no rights in the property purchased as against the creditors of the seller. His status is that only of a trustee or receiver. This is in violation of the bulk sales law. Okay? For the benefit of all the creditors of the seller. Yes, the buyer may have possession. He may have title, but his title is only equitable title. And it will not ripen into a legal title as long as hindi nababayaran ang creditors. Therefore, ang title niya lang is as a trustee or receiver, meaning he is only acting, okay, in behalf of the creditors. Yes, okay, as such, he is responsible for the disposition of the property, meaning, since the buyer is only a trustee or receiver, he cannot dispose the property. Once he sells the property to another buyer, he will become personally liable. With regards to the goods, yung binenta sa kanya ni vendor, wala siyang personal liability. Gets? Si vendor ang may personal liability kay creditor. Okay? Gets yun? Kahit pa nasa kanya na yung goods si buyer. Okay? Pero kapag binenta ni buyer, in-dispose niya pa further yung goods sa ibang tao, that's the time na mayroong personal liability. Gets? Gets ba? Question? Wala? Please? Gets? I proceed, okay? Rights and liabilities, sale, purchaser, and creditors. Application by the seller of proceeds of above sale to the payment of some of his creditors does not affect the buyer's liability to other creditors who received none of the proceeds. Okay, meaning, kung may nabayaran na some creditors, okay, at merong iba na hindi, okay, it does not affect the buyer's liability to other creditors who receive none of the proceeds. Therefore, may possibility pa rin na maging liable si buyer sa mga unpaid creditors. Just in case the buyer has sold subsequently the goods. Okay? The mere fact that on his request the creditor sought to collect from the does not raise an acceptable reason to sue them on his primary liability. Then, speaking of the personal liability of the purchaser. Okay? So, dapat, si purchaser, kapag binili niya yan, dapat hindi niya ibenta. Okay? Kasi he's only acting as a trustee or receiver. Okay? Gets? Okay pa? Okay pa kayo? Rights and liabilities of purchaser and seller. Okay? The above sales law do not in any way affect the validity of the transfer as between the immediate parties thereto, as I said. Okay? As between the seller and the buyer, that is valid. Walang problema dyan. Okay? A sale not in compliance with the above sales law is valid as against all persons, pero hindi kay creditors, other than the creditors. Notwithstanding in non-compliance with the law, title to goods transferred passes to the transferee. So it will pass to the buyer as between the parties who are transferred, where it remains until the vested by proceeding instituted by a creditor for that purpose. Okay, so eventually, malalaman din naman natin kung merong creditors na maghahabol later kay vendor or kay merchant. Okay? But, if wala, the title will passes, presume na siya ang owner. But if merong creditor na mag-claim, then babalik tayo dun sa discussion natin kanina, na yung title niya lang is equitable title. Okay? Hindi legal title. Okay? Between creditors and subsequent purchaser. Okay? The law does not confer on the creditors of the vendor who fail to comply with its requirements the right to pursue the property in whosever hands it may fall. So, hindi sinasabi ng box sales law na kahit kanino mapunta yung goods, yun ang habulin ng creditor. Hindi. Hindi yun ang sinasabi ulit. Ang sinasabi ng law, okay, it must show na si buyer is fraudulent mismo. Or, si subsequent buyer has knowledge that the transfer was against the bulk sales law. If that is the case, then he is personally liable to the creditors. But, if the circumstances are such as to bind the subsequent purchaser with constructive notice that the sale to his vendor was fraudulent, the property will be liable in sense to creditors of the original vendor. So, hindi lahat ng purchaser at subsequent purchaser, take note ha, hindi yung original buyer subsequent purchaser. Okay? Kailangan sila mismo ang fraudulent or the vendor is fraudulent, or may knowledge sila or may notice sila na yung sale before nangyari yung sale na sa kanila is fraudulent. Questions? None? Am I going too fast? Or would you like me to take it slow? Ano? Am I too fast? No. Sakto lang. Kaya. Sige. Remedies available to creditors. So what are the remedies by the creditors? This is one against the goods. Against the goods for the furnitures and equipment. Hindi sa pera. So kung the remedies about the goods The remedies, execution, attachment, garnishment, or levy, or proceeding equity. Okay? Hindi ang action mo, just like what I explained before in our previous topics, kapag may utang or kapag hindi nakabayad, ang action mo is action for collection of sum of money. Diba? Siyempre, pinutang nila eh. Siyempre, ang action mo is collection of sum of money. Okay, but under the Bob says law, this is not your action. Your action is on the goods. Your interest is on the goods. On the furnitures and fixtures. Okay? Kaya, ang remedy mo is not collection of sum of money, but the levy, the execution, the attachment, the garnishment of the goods or the furnitures and fixtures. Ang ordinary action for money judgment will not lie unless the purchaser has sold or disposed of or dealt with the property so as to become personally liable to the creditor. So, iduktong mo to dun sa kanina na discussion ko. Okay? That if the buyer, the buyer of the goods or the fixtures or the furniture or the equipments subsequently sold or disposed or dealt with the property, sabi natin kanina personally liable siya. Doon mo siya pwedeng filean ng collection for sum of money. So, if hindi naman nabenta ni buyer sa iba, wala kang action. Gets? Ang action mo kay vendor. Okay? Pero kung nabenta niya sa iba, doon mo pwedeng habulin for money judgment. Okay? Questions? Section 5 talks about the other duties. So, una, execute a written sworn statement. Pangalawa, deliver the sworn statement and apply the pro rata payment to the creditors. Yun yung pangalawa. Pangatlo, make a full detailed inventory of the goods sold. Pangapat, you preserve the goods subject of the sale and notify every creditor whose name and address is stated in the written sworn statement. Okay? So, hindi lang doon natatapos sa written sworn statement. Mag-inventory ka pa. Since ang subject naman ng sale natin is hindi normal sale, kundi bulkuhan. Di ba? Dapat nakalist dyan kung ilan lahat ang nabenta mo. Para din ma-counter-check nyo. Di ba? Later on, sa inyong auditing, okay, you will audit if the goods sold are you compare the actual goods sold dun sa inventory, kung tama ba. Okay? So, check nyo yan. Okay, yung ginagawa nyo, the inventory, i-audit nyo. Okay? You preserve the same, showing the quantity. Of course, dun sa inventory, the cost per each product or article. Okay, so, nakalagay doon yung individual cost. Okay? Alam nyo na yan. Kasi accountants kayo, di ba? Alam nyo na yan. And notify every creditor na nakalagay din sa list. So, it's not enough that you make the written sworn statement, that you delivered that to the buyer, that you applied the payment of the buyer to your utang. It's not enough na gano'n. You must also notify all creditors that you have na ibebenta mo yung mga goods mo. At least 10 days before transferring possession thereof. So you notify them at least 10 days before transferring possession thereof. How do you do that? Personally or by registered deed. When we say personally, you give the notice to the creditor. Diba? Creditor. Ito yung nabenta ko kay ganito, na goods ko. Lahat binenta ko. Or halos lahat nabenta ko. Ito yung list. Ito yung cost. Okay? Or by registered mail. Not by ordinary mail. Take note ha. Hindi yung pa LBC. No. Hindi yun ang sinasabi natin registered mail. Sa post office. Okay, yun ang registered mail. Okay? Of the price, terms, and conditions of the sale. Okay? Questions? None? Oh, lapit na matapos. Sufficiency of notice. There must be substantial compliance. Okay? If the lease furnished is not verified and omits to name certain creditors, so kulang-kulang. And hindi rin sila notified who are not notified, the sale is void as to such creditors, whether their admission is fraudulent or otherwise. So, importante, complete yung written sworn statement and the notice. Okay? Question? Non-timeliness of the notice. So, sabi namin kanina, 10 days before transfer of possession. But there is a case, ang sabi niya, it is sufficiently complied with by sending the notice by registered mail at least 10 days before transferring possession of. Okay. Of course, if you choose between personal or registered mail, it depends on the distance between you as a seller and the buyer. Of course, kung nandito din lang and mas logical, may personal mong deliver, personal, di ba? Kapag malayo, doon tayo gumagamit ng registered mail. Violations, okay, if you knowingly or willfully make, deliver, or cause to be made, or deliver a statement which shall not include the name of all. Okay. In short, you violated Section 3. Okay? Name of all creditors, the correct amount, dapat tama yung amount. And to become due to each of them. If you are not sure and merong interest stipulation sa inyong contract, you put the interest rate in your contract for proper determination. Okay? Of course, nakalagay dyan kung sino na yung due at yung mag-become due. Or shall contain any false or untrue statement. This one kasi is madidiscover mo lang after no sale. Kapag merong nag-claim na creditors which might show the falsity or the untruthfulness of the statement. Questions? None? Okay. Without consideration, this one I discussed as an exception to the sales involved, okay? It shall be unlawful, okay, transfer title to the same without consideration or for nominal consideration. Why? Kasi normally under the civil law, itong mga yan, in the fraud of the creditor. Those are fraudulent acts against the creditor. But under this law, it declares them unlawful. And ma-appreciate na siya kapag nalaman niya yung penalties. Okay? Later on. Exemption. Another one na exemption. Diba? Kapag the vendor, the transferor, the assigner does not act in his own capacity but rather acts in another capacity such as an executor, administrator, receiver, assignee, or a public officer. Section 11. Section 11 is the penalty. So, anong penalty? Pagkakulong. 6 months to 5 years. Okay? 6 months to 5 years. Malaki-laki na rin yan. Diba? 6 months to 5 years ka nasa kulungan. Sabihin mo, maximum ang i-impose sa'yo ni judge kasi may personal na galit sa'yo si judge. 5 years kang nakulong. Diba? malaki-laki din yan. 5 years libre ang pagkain mo, syempre, sa kulungan ka. Hindi ka problema sa trabaho. Buhay ka di ba? Pipilitin ka pang kumain. No, kain na. Kain ka na talaga. Isipin niyo rin, magtrabaho ba kayo o magpakulong ka lang? Di ba? O, kung ikaw mahirap ka, nakatira ka na sa streets, wala ka nang makain, ganyan. Kumatay ka na lang. Huwag naman yung mag-rape. Magnakaw ka na lang. Pero pag nakaw kasi, baka hindi ka rin kulong o makalabas ka din. Siyempre, medyo mabigat naman. Kung matay ka lang sa tingin mo, gago. Yung talagang gago na. Diba? O, tapos doon ka na sa kulungan. Pero kung mayaman ka at nakulong ka, iba din. Diba? Kapag mayaman ka at nakulong ka, yung kulungan mo, iba din. Bayaran mo lahat ng guards. Aircon, may concert pa. May pa-concert pa sa loob. Totoo yun, di ba? Totoo yun. Takot pa ang mga warden minsan sa nakakulong. Totoo yun. That's the truth. Okay. Kasi hindi mo alam, bata yan ni ganito, bata yan ni ganyan. Tao yan ni ganito, tao yan ni ganyan. Mga matataas ng pangalan. Okay? That's why you, as the younger generations, you strive hard to change that. And you cannot change that from the outside. Kaya yung sinasabi ng iba, nagtatalak-talak sa social media, you can do that all you want. I don't have nothing against that. But you do that when you get inside the government. Okay? Kasi you cannot do that. Lalo na kung bagong pasok ka sa trabaho, alangan na magreklamo ka kagad. Sa tingin mo, tatagal ka. Siyempre, you must learn the system. Why is the system like this? Bakit ganyan? And you will see that it is very hopeless. Kasi I'm just like you before. It's very active. I was involved pa sa pag-monitor ng elections. Very active ako dyan. But then, when you get inside the government, you realize, oh my God, kahit saan kayo pumunta. Off the record,